Are we ready to go? Miss
Good afternoon.
Stewart, nice to see you. Are we ready to go?
I believe so. We don't have any members of the public in the room in person. We do have on Zoom two attendees, one of which I believe is from the applicant's team.
Okay. All right. So tell me when you'd like me to get started, and I will do so.
We're ready when you are.
All right. Thank you. Um, we'll go on the record now. The time is about 2 o'clock, just slightly thereafter, on June 11th, 2026. And this is a hearing for Deschutes County file numbers 247-26-0000. There's 4054-CU and 247-26, another 4055SP. My name is Greg Frank, and I am the hearings officer who's been assigned to this matter. And before we turn to the particulars of the hearing, I would like to turn things over to Deschutes County Planning staff member Ms. Stewart and have her describe how the electronic process is going to work today.
Good afternoon. For the record, my name's Audrey Stewart. I'm an associate planner with the Deschutes County Planning Division. The item for the hearings officer is a conditional use permit and site plan review to establish a dog training facility. Prior to today's hearing, the applicant requested a continuance. The county's procedures ordinance requires today's hearing to be opened, and if desired, anyone can testify. Pursuant to Title 22 of Deschutes County Code, the applicant shall receive a continuance if they request it prior to the initial hearing. Hearings Officer Frank will consider the continuance request and will make a decision on when the next hearing will be scheduled. Hearings Officer Frank, can you confirm if you would like to hear from the requester of the continuance or any other parties prior to making a decision, or are you ready to make a decision?
I have no reason to dispute the request for the continuance so long as the applicant has agreed to continue the clock and extend the time clock for the decision. And so long as that occurs, then I'm okay with continuance. Ms. Stewart, do we have agreement with the applicant, or should we put the applicant on to give us their position on that matter?
So pursuant to, it would be 2224-140E of our procedures ordinance, the continuance request by the applicant does toll that 150-day.
Okay, I'm aware of that. I just wanted to make sure that we were all on the same page with that. Okay, so no, I will grant the continuance. My understanding is the continuance request has been discussed with the applicant and staff, and August 4th at 10 a.m. Is the requested time. Is that correct, Mr.?
Correct, hearings officer.
Okay, then I'm willing to do that. I'd like to also make note that Ms. Stewart forwarded me information from one participant that wanted more time and wanted an evening hearing. And before we go on, I'd like Ms. Stewart. I understand you've communicated with that particular person, but could you put it on the record? What we have going here with respect to the evening hearing, and then I will talk about extending potentially the time for testimony.
Certainly. So that public comment was uploaded to the record today. They had requested an evening hearing just to accommodate people who have work schedules. I responded and said we try to be consistent with our hearing scheduling, understanding that we can't always find a day and time that works for everyone. We like to have staff available, including, room support, IT support. So we've moved to having these during the workday.
And that is my understanding of how the process works. I am not going to request or even suggest that we have an evening hearing. I'm going to, though, for the public record, make sure folks understand that there's two ways to get information to me to ultimately allow me to make make a decision. One is public testimony, and that's what's being requested, is having a hearing in the evening where the public testimony can occur at that time. The second method is submission written testimony. And for those of you who have videos, you know that I'm not 25 years old. I've actually been doing this a really long time, and I have found that the history of hearings officers' decisions can be traced, I think, strongly to what is in writing. And I find that when I'm making a decision, I tend to, on occasion, go back and watch or listen to the recording of the hearing. But more importantly, is that what's submitted to me in writing. I can assure you that I print out most testimony. I copy it and take a look at it. Not only look at it, I read it carefully. I go through a lot of highlighters because I highlight what you write in your written testimony, so that it allows me to outline what I need to do and make a decision. So my suggestion to the folks that are concerned about not being able to testify at a public hearing, I fully appreciate that. I like to be at public hearings. I'd like you to be at public hearings as a participants, because we can look at each other's eyes and kind of get a feeling what's going on. But ultimately, the decisions in these cases are made based on the legal issues that are raised, the support or the arguments and how valid that is, and the evidence that's presented. And that evidence that I'm talking about is what I tend to look at in the written documents really carefully, and tend to look at it over and over again. So I'm just letting you know that I'm not trying to slight anyone by not having an evening public hearing. I understand I've done in the past evening hearings as well as day hearings. But I'm going to tell you that if you can effectively communicate to me in writing just exactly what it is you want, and that gives you a lot of time to sit at your desk, sit at your table, compose your thoughts, and organize those thoughts. That's really, really helpful. So anyway, I'm going to deny the request for a evening hearing. As far as the time limits, I will tell you that historically, at least what we've done and the recent past, is the applicant tends to get 30 minutes. The agencies in support or that talk about the application get 10 minutes. The public, each person would get 3 minutes. And the applicant gets 10 minutes rebuttal. Staff usually gets time at the end where they get to comment on what's going on. Um, Unless I hear an objection from staff, I'm going to extend the public time to 5 minutes, and I'm going to and the reason I'm doing it now is that they have an opportunity to plan ahead before they come to the hearing, and they don't have to get the scissors out and start cutting their testimony or whatever. I want them to have an understanding that it'll be 5 minutes. I also want the folks that are listening, and anybody that looks at the recording of this, that I tend to be fairly strict when it comes to people repeating or saying the same thing over and over. So just because I'm giving you an extra couple of minutes to talk doesn't mean that I'm asking you to repeat whatever the testimony has been before. I fully appreciate when people say, I agree with the prior person who testified, because I listen to those people as well. So I will extend it to 5 minutes unless I have an objection from staff for public testimony.
No objections from staff.
All right. Then I think the next thing we need to kind of take a look at is, if I'm correct, Ms. Stewart, is to determine whether or not anyone wishes to testify today. So if you can kind of follow up on that just ever so briefly and do the logistics of that part.
Correct. Thank you, hearings officer. So I see 2 attendees on our Zoom If you did want to testify today, could you please use the raise hand feature? And hearings officer, I'm not seeing either of the attendees raise their hand on Zoom.
Okay, and just to make sure, with that, no one requesting to testify today, do we need to go through the balance of the standard comments about how to testify and all that? I'm gonna defer to you on that part.
No, we don't need to go through that full hearing procedure. I do have a couple of just procedural notes to
Okay.
get on the record, and I can do that whenever
Yeah,
whenever the hearing's off.
the whenever is right now. Thank you.
Thank you. The first I wanted to note, I did get a public comment that pointed out the staff report that was issued on June 4th had the title of findings and decisions, which it should be a staff report since it's not a county issued decision. I'm going to just correct that. It was a clerical issue and re-upload that to the record. And then I posted on the webpage the new hearing date and time of August 4th at 10 a.m. It will be the same Zoom link that works. So anyone who has that old notice, the same Zoom link, you don't have to change anything for that new date. And those were all of my notes, hearings officer.
Okay. Then with that, I see that we can probably end this initial hearing. Just as a reminder, this hearing will be continued until August 4th at 10 a.m. We will use, as Ms. Stewart indicated, the same link and the same access. People are certainly welcome to come to the hearing room if they so desire to do that. I have extended the public testimony from 3 to 5 minutes. The rest of the time limits will be the same unless I hear requests otherwise. But at this point in time, those time limits will stand. So unless there's something further from you, Ms. Stewart, we'll adjourn until August 4th.
No, thank you, hearings officer.
All right. This portion of the hearing is now closed. We will all be back on August 4th to resume. Thank you very much.